Right, I believe we've gone live. Welcome everyone. My name is Roger O'Keefe. I'm Professor of International Law here in virtual sense at Bocconi University. I also had the great pleasure of working with James Crawford in various academic capacities between 1996, I guess, was the first time we started working, and 2014, 15. It's my great honor, privilege and pleasure to have been invited to speak at this event alongside Professor Céline Lévesque, who is a full professor at the University of Ottawa, and Dr. Federica Paddeu, the Derek Bowett Fellow of Law at Queen's College, Cambridge. The way we're going to run this is that I will give first just a very brief overview of James's career and my points of contact with him in that regard. Federica will then introduce herself, Céline will introduce herself, and then Céline will launch into probably the most substantive of the three contributions, insofar as Céline is the one who really knows about international investment law. However, such is the fame, expertise, and indeed contribution of the late James Crawford that Federica and even I know something about international investment law. Well, James Crawford, who was born in Adelaide in South Australia, a point that he was always happy to make, a proud South Australian, really the only state in Australia which has a slightly different accent from the rest of Australia because they never had Irish convicts. He did, in the 1970s, his Bachelor of Arts and Bachelor of Law at the University of Adelaide, before in 1979 going to the University of Oxford to pursue his DPhil, or what others would call the PhD, under Professor Ian Brownlee, who promptly told him that he did not have a topic, because James wanted to write on the creation of states in international law, which Professor Brownlee said was simply a matter of fact. They exist or they don't. And James, although it took him, I think, something like 1,500 pages actually to make his point, nonetheless wanted to show on the back of a postcard, as he always said, or indeed on the back of a postage stamp, one very simple point, that the creation of states is a matter of both fact and law. Well, his creation of states in international law went on to become a classic. He went back to Adelaide as a condition of his scholarship, promptly became a very, very young professor, before tiring of that somewhat to go and join the Australian Law Reform Commission, where in particular two of his reports became instant classics, one of them on state immunity, which led to the Foreign States Immunities Act 1985 in Australia, the report for which is still used as an academic source, and a report on the status and potential status of Aboriginal customary law, that is, the customary law of the Indigenous Australians within the Australian legal system. Towards the end of that period, he was elected to the Institut de Droit International at an absurdly young age in 1985, becoming a titular member in 1991. In 1986, he became Challis Professor of International Law at the University of Sydney, where he also taught constitutional law, where he stayed until 1992. And it was in this capacity that I first came across James in two ways. I was a student at the University of Sydney, and many of my friends in the years above me used to complain about this lecturer who taught constitutional law at such a high level and assuming such knowledge on the part of the students that it drove them crazy. They all loved him nonetheless. I also met him personally at a dinner at which Nelson Mandela was present, and in which James very kindly and affably for the whole dinner spoke to my mother, a point that he reminded me of many years hence when he kept asking how she was. 1992, he became the Whewell Professor of International Law at the University of Cambridge, and if I'm not mistaken, the first ever Whewell Professor to come from outside Cambridge. The same year, he was elected to the International Law Commission of the United Nations. In 1994, having been handed what looked like the impossible task of drafting a statute for a permanent international criminal court, basically turned it around within a year and developed what became the draft statute for the International Criminal Court. Having done such a good job, they thought they'd give him another poison chalice, and that was the Articles on the Responsibility of States for Internationally Wrongful Acts, at that point in their draft form, which again he turned around with his customary blend of incisive international legal analysis and what we might call diplomatic astuteness. He remained Whewell Professor of International Law at the University of Cambridge until 2014, and again, this is where our paths crossed, first when I was an LLM student in 1995. Then from 1996 onwards, as a PhD student, I did lots and lots of research for him, including on the reference in the Canadian Supreme Court in relation to the secession of Quebec. From 2000 onwards, I was fortunate enough to be his colleague as a lecturer there, and we worked together at the Lauterpacht Center for International Law, where he was director for many years, and indeed within the Faculty of Law, where he was the chair and I was stuck doing more boring stuff. During this time, his practice boomed as a counselor, and then eventually as an arbitrator in many landmark international investment cases, including sitting in the arbitration panel for the SGS in Philippines award and the famous Vivendi Annulment 1 decision, where he sat on the annulment committee. In 2014, he was elected to the International Court of Justice, on which he sat from 2015, but was sadly taken from us all too quickly. It will be chiefly in the context of his contributions to international investment law and indeed international economic law more broadly that we will be speaking, but also we will be offering personal reflections on his career more broadly and on him as a person. At this point, then, I will hand over to Dr. Federica Paddeu, who will introduce herself, then to Professor Céline Lévesque.
Thank you, Roger. That was a really lovely summary of a very extensive career. So I am Federica Paddeu, and I'm a fellow of Queen's College in Cambridge. I, like Roger, experienced James's career in many different guises. The first time I met him, having barely heard of him, I must admit, as a young law student in Venezuela, I met him as an LLM lecturer here in Cambridge. So he was lecturing in the course, and then after I finished my degree, I approached him with a lot of trepidation and said, "Oh, is there any chance that you have any work that I might do over the summer?" He said, "Why don't you stay on and act as my research associate? You need to get a first in the LLM," which I promptly did, and then ended up working for him for a year, which was fantastic. At the time, he was working on many cases involving Latin Americans, so my ability to speak Spanish and read lots of legal documents in Spanish was really useful at the time. I then stayed on as a PhD student with him, and I worked on state responsibility, which is what I will talk a little bit about later. And unfortunately, never managed to be a colleague of his like Roger in the law faculty, as I became appointed a postdoc in 2013, so just a year before he left. But I've been in touch with him. Well, I was in touch with him throughout my career, and he was, I have to say, without him, I would not be here. So I am very grateful that he put faith in this Venezuelan lawyer who had never heard of him before at the end of my LLM. Céline.
Thank you. It's an honor to participate in this tribute. I have to say I'd heard about James Crawford many years before I had the chance to meet him, and it was in the mid 2000 at the ASO annual meeting in Washington, and someone introduced me, and I have to say I was quite starstruck, so I probably mumbled a few things and ran out of the room because I was quite impressed, but later I had a chance to crosses path again in 2009 during the hearing on Chemtura versus Canada. I had the opportunity to see him in action. And later the same fall, he actually chaired a panel at a conference I was a speaker at. It was a joint SIEL event on the role of science in international law in Helsinki. And so that was another opportunity to interact with him, but was not before really 5 years ago that I got to know him better personally, as I was appointed to sit as an arbitrator in the NAFTA Chapter 11 case, for which James was appointed by the parties as president. So my reaction was like, this is the greatest day of my life. I'm going to sit on my first tribunal with James Crawford. So I couldn't believe my luck. So I had to calm down a bit, not to sound like a groupie in all our interactions, but I did manage, and he was incredibly kind. And I'll stop there for the general intro. Now I'm gonna shift gears and speak more about James' contribution to international economic law. And when I accepted the invitation to participate in this late edition roundtable honoring James' memory, I asked myself, how can I possibly do justice to his contribution to this field? James was a giant of international law generally, but also of international economic law. So where do I start? Do I look at the ILC's articles impact? Do I look at his academic writing, maybe his council work, arbitral awards? Oof. So finally, I decided to focus on ISDS So I soon realized that was not going to work either. So I decided to focus on Chapter 11, NAFTA Chapter 11, and James' legacy. James was appointed to 5 NAFTA Chapter 11 tribunals. I believe it's the most of any individual arbitrator under NAFTA. He was appointed twice as president and 3 times as co-arbitrator, both by claimants and respondents. For today, I'll only highlight 3 of the cases, 1 of each against the US, Mexico, and Canada. And in 2 of them, James did not preside over the case. So one may wonder, how can a contribution
to have lost Céline for a minute there. Céline, are you out there? I hope so. Fede, should we go on with you, and then when Céline comes back, maybe reconnect with Céline?
Yeah. Okay. Absolutely. Yeah, okay. Absolutely.
Okay, great. So, hand over then.
So I was going to start out with a joke by saying that Céline is the true international economic lawyer. And as you'd already hinted, I wasn't. I'm just an outsider to the discipline, but one who likes to peek in on investment law and then cut in with an Australian joke. I'm a sticky beak in investment law. But there you go. Now that doesn't work as well. So I will be speaking about one of James's greatest accomplishments, which Roger has already mentioned. And that is without doubt the completion of the articles on the responsibility of states at the International Law Commission. And I think it is easy nowadays to underestimate just what a feat that was. He'd brought to a close in only 4 years, a project that had been under discussion at the ILC for 40 years, and a topic which had sown divisions at many steps along the way, not just in the ILC, but also among states in the 6th Committee of the General Assembly. So an impossible task, as Roger called it earlier. And this he did by providing much needed simplification to a text that was often very complex, and that which he managed to do without sacrificing the nuance that was needed from a project like this. And by also finding compromise solutions where divisions, deep divisions existed, which he managed to do without sacrificing the coherence and the completeness of the project. Likewise, and this is admirable, he never abandoned a vision of what international law needed from a project on state responsibility in the 21st century. And I'm thinking here really about his greatest contribution in the ILC articles, which are the provisions on multilateral obligations. Now, the articles were a major contribution to international law as a whole. And to put this in context, in one way or another, international lawyers had been preoccupied with the codification of the law of responsibility since the early days of the Institut de droit international in the late 19th century. And it is often said that all prior projects of codification of responsibility failed because they tackled the topic from the wrong angle. So as an attempt to codify rules on the protection of foreigners and their property, so-called primary rules of international law, nowadays partly covered by investment law. Namely, they were trying to codify the obligations of states. And while it is true that the angle was unhelpful, especially at a time when states were divided between national treatment or international minimum standard of treatment in the first part of the 20th century, and later against the background on the debates of the new international economic order at the time when García Amador started his tenure as special rapporteur at the Commission, I think that pointing to the wrong angle overlooks the fact that the difficulties run much deeper than that. There were disagreements about fundamental questions of what responsibility should look like in an order that was regulating the conduct of abstract entities, that was horizontal, decentralized, without mandatory dispute settlement. Now, what was the role of fault and damage in this order? Were they necessary for breach? Whose conduct should be attributed to the state? What is a state to determine whose conduct is the conduct of the state? Should there be defenses, and in so what defenses, and so on. Sir Robert Jennings had aptly described responsibility as one of the most traditional and yet elusive, unsettled, and intractable problems of international law. The ILC's own work on this topic during the first reading of the articles is testament to this. Even after the enlightened decision to focus on secondary rules only, so roughly from the mid-1960s onwards, it still took the Commission the best part of 30 years to settle on a set of draft articles. And they achieved this by leaving pending a lot of disagreements. So the text that was adopted in 1996 was a compromise text where disagreements abounded. So concluding such a project in 4 years, as James did, was a tremendous achievement and as per se, a fundamental contribution to international law. But it was also a fundamental contribution to international investment law. Investment tribunals were quick and in great numbers to rely on the articles on state responsibility. There have been some references to the articles adopted on first reading, so before 2001, but 2001. And in fact, the newly minted articles, which were adopted in August of 2001, were referred by the tribunal in CME and Czech Republic in September of 2001, so only a month after their adoption. Now, in 2016, a technical report listing prepared by the UN Secretariat showed that the articles were referred in 264 decisions by arbitral tribunals. And these represented about 72% of all the decisions that refer to the articles surveyed by the Secretariat. Now, according to research by Sotirios Lekas, the majority of these 264 decisions were investment awards. So about 150 of those were investment awards. So out of a set of 13 international bodies that were surveyed by the Secretariat, investment awards constituted about 40% of all citations to the articles. And in fact, Lekas also shows that in investment law itself, state responsibility is one of the most common issues that arises in investment arbitration. So out of 444 decisions cases that led to decisions since 2000, at least 200 of these refer to the articles or the previous version of the articles. Yet, as James noted, and as David Caron had foreshadowed, there was something of a paradox in this early and wholehearted embrace of the articles. Now, with his usual wit and his eye for a good metaphor, James described this embrace a bit like a drowning man grabbing at stick at sea in the hope of having some certainty. For Caron, this was the risk of counsel and arbitrators just taking the rules and applying them unthinkingly, overlooking the fact that many of these rules involved elements of progressive development and were therefore compromise solutions where disagreements remained. In fact, James explained in 2010 in an article about state responsibility and investment arbitration that the rules in the articles on responsibility were predicated upon a process of integration into practice, which is itself inherently uncertain. That is, the formulations of these rules involved a dialectical process that was both led and was led by practice. The rules were drafted so to ensure that this process continued. They were sufficiently abstract, sufficiently flexible. They needed to allow adaptation as the conditions in which state responsibility arises change over time. The articles were not the last word. They couldn't provide investment tribunals with the clear rules that they could just apply in straightforward syllogistic fashion. So it shouldn't be surprising that in many instances, tribunals had difficulty understanding the rules, had difficulty discerning the positive law aspects of them from the progressive development law aspects of them, and applied them to case law that in some respects is contradictory and inconsistent. But despite this drawback, the wholehearted embrace of the articles by investment tribunals has also been beneficial, if not only at a granular level, at least from a systemic perspective. It has fully integrated investment law into general international law, and it has also provided a structure and a blueprint to investment disputes and investment awards. In that article from 2010, James had remarked that investment tribunals' engagement with the articles was sometimes little more than signposting. The citations to the articles were the wallpaper or the furniture rather than the architecture of these decisions. In 2010, 20 years after their adoption, it seems to me they are becoming integrated into the architecture of investment awards if they are not already part of that architecture. And in this sense, the articles constitute a tremendous contribution to the field of investment law. The articles, one of James's most important contributions, are now embedded in international investment law. And this is without doubt a tremendous contribution for any scholar to achieve. Thank you.
Well, thanks, Fede. Well, we have Céline back. Céline, would you like to pick up where you left off? And we'll take it from there.
Yes, thank you. Sorry about that. This always happens at the worst times. So I'm not sure where exactly dropped out, but I will just go back maybe 1 minute and hope that I didn't lose too many people. So I was just saying that James had been appointed to 5 NAFTA Chapter 11 tribunal, which to me I think is as far as I know, it's a record. And I'm just gonna highlight 3. And in 2 of them, James was not the president, but in terms of contribution, you'll just have to bear with me till I get to that point. So I think I was just going to say that in 2010, James published an article entitled 10 Investment Arbitration Awards That Shook the World, Introduction and Overview. And he had not established the list himself of these 10 decisions. It was rather the result of a voting procedure, something having to do with the IBA. In any case, James had to declare that he was a member of the tribunal in the co-equal top 2, as well as the number 3 award on the list, all non-NAFTA. And he noted with his usual sense of humor that his enthusiasm for the top of the pops may as a result be suspiciously muted. The reason I bring this up is not for the awards he provided, while very interesting, but rather to note what James thought of the potential broader significance of judicial and arbitral decisions beyond the parties and the particular dispute. He referred at first to famous public international law cases before adding the following, and I quote, "In the closeted world of international investment arbitration, by contrast, one cannot expect fame on such a scale. Some would say on any scale, but BIT awards can change the way we think about our subject. And for us and for our purposes as investment lawyers, that counts for something. I think this encapsulates perfectly James' contribution. He did make a very significant contribution to the way international investment law is thought of, and he did it humbly, and that counts for something. So back to NAFTA Chapter 11 and James' contribution. First, it's helpful to remember that such cases started in the mid-1990s. So early cases had a great impact and still do today. For many years, there were more awards under NAFTA Chapter 11 than any other single IIA. So the cases I will briefly highlight are Mondev versus United States, 2002, Waste Management versus Mexico, 2004, also known as Waste Management 2, and Chemtura versus Canada, 2010. As an empirical matter, researchers have noted that both Mondev and Waste Management 2 are amongst the 5 most cited cases relating to the interpretation of the FET standard, or Fair and Equitable Treatment Standard. To focus on Mondev a bit, one of the things the award did was to chart a path for NAFTA Chapter 11 tribunals following the adoption of the somewhat controversial 2001 FTC Notes of Interpretation on Article 1105. The tribunal held the interpretation of Article 1105 was to be bound by SIEL, but as it evolved, not frozen at the time of NIR. At least half a dozen NAFTA Chapter 11 awards have referred to this holding. It was also referred to beyond NAFTA, including in Philip Morris versus Uruguay, to which I shall return to in a minute. Management 2, the tribunal presided by James, provided a synthesis of past Chapter 11 holdings on Article 1105 and pointed to the emerging applicable general standard. According to one database, that statement of the law, if you will, has been cited specifically 85 times, including in 11 NAFTA Chapter 11 cases. While some tribunals have tried to tamper with it a bit, let's just go back to the original. So to this day, it stands and is highly influential. The final case I wanted to mention is Chemtura versus Canada, for other reasons than the last two, and not having to do with citations. As you may remember, this case was presided by Gabrielle Kaufman-Kohler, and the co-arbitrators were Charles Brower and James. The case concerned the regulation of pesticide and addressed both Article 1105 and 1110 on expropriation. One of the notable things about Chemtura is its treatment of the concept of margin of appreciation and the call for the tribunal to conduct assessments in concreto, including, in this case, taking into account the fact that certain agencies manage highly specialized domains involving scientific and public policy determinations. For the tribunal, it was not an abstract assessment circumscribed by a legal doctrine about margin of appreciation in general. I think this approach exemplifies a trait recognizable in other awards James was a part of, a focus on the essential and the facts of each case, and not a reason or an excuse to build some grand legal theory. On another front, the holding power doctrine, while subdued, is also significant. I did say I would go back to Philip Morris versus Uruguay, in which James was a co-arbitrator. The 2016 award in this case relies on Mondev, relies on Chemtura for the interpretation of FET and expropriation. And in particular, it is approach to the margin of appreciation in concreto, as well as the police power doctrine. Much more could be said about the impact of many other cases James was involved in, but I will stop here with this conclusion. Without the need to having been a fly on the wall of many tribunals' deliberation room, one can say without hesitation that James Crawford has made a very significant contribution to the development of international economic law under NAFTA Chapter 11 and much beyond. So I will pass back to Roger and to
Thank you, Céline.
add.
Yeah, that's wonderful. Well, I'm going to have my 2 cents worth now. There'll be a bit of international investment stuff in there, but there'll be some personal stuff as well. And I'm going to divide it up into, on the one hand, the professional, and on the other hand, the personal. But the personal with James was always professional as well. He was not a person who put on the Hawaiian shirt at weekends and forgot about it all. Most of his friends, 3 of his wives, were involved in the same field. He took joy, he took pleasure in his work. And so why would you get away from it all? So to a certain extent, the personal is the professional with James, but that's roughly the division. And I'm going to introduce each part of it with an anecdote. Now, the first one, Céline is going to have to forgive me for, as Yves Daudet will have to forgive me for, because it involves a French accent and Yves Daudet. So when I was teaching 1 year at the Hague Academy of International Law, I had the very good fortune to meet the wonderful Yves Daudet. And he pulled me aside and he said, Roger, you are Australian? I said, yes, I'm Australian, Yves. Okay. Do you understand a single word that James Crawford said? And I said, well, I do. I mean, it's an Australian accent and it's South Australian, which is different. I agree, he mumbles, but I understand. And he said, well, we are on the curatorium of the Hague Academy, and we don't understand nothing that he say. He said, oh, Kenneth Keith, oh, even less. But he said, but you know, we think, this is James Crawford speaking. He is a genius. And so we just say yes. And I thought, what a statement of a person's career. That such is the respect that people just agree. Of course, it can be dangerous, but that says something about the esteem and the regard within which James was held. And in such regard, in 2 areas, what you might roughly call practice, as counsel, arbitrator, etc., but also in the academic life. And the thing to understand about James is that he did not skimp on the latter. Many international lawyers, and this is not an accusation or anything, but they get to a point where they think, okay, well, now's the time to practice, and the academic stuff really takes a back seat. With James, this was simply not the case. He led 2 lives, really, which of course led to his famous sleep pattern of 3 maximum 4 hours a night. He was fully an academic and fully a practitioner. So much so was he fully an academic that he even accepted really unpleasant tasks like being the chairman of the Faculty of Law at the University of Cambridge. He perhaps could have said, I'm too grand for this, but that was not James's style. But even in that context, it was interesting to see how the Workers' Council fed into it, even in comic ways. So I remember we had a 8:30 meeting one day, and James was late to what you might call the inner cabinet of the faculty. Finally, when he turned up, he said, without a hint of irony, I'm very sorry. I'm sorry I'm late. Nicaragua has just invaded Costa Rica. It was a slight exaggeration. Nonetheless, it was wonderful. Most people would say the dog ate my homework, but James said, Nicaragua has invaded Costa Rica. Of course, if you're going to invade a state, invade the one without the army. He was famous and much respected for his handling of the faculty board meetings because this handling was brisk. Rather than worrying about the commas and the full stops, he would say, "Does anyone have anything to say?" And after about 0.55 of a second, he would say, "We'll move on." And people love that, okay? If you have something to do, give it to the busiest person. In terms of his academic work, he is a great example of how the generalist becomes the best specialist, and in a way, how really the best specialist has to be a generalist. Federica has already mentioned what he brought from the law of state responsibility to international investment law. I'd like to mention how his abiding interest in the relationship between international law and national law, both substantively and jurisdictionally, fed into what to me is the most interesting contribution of his to international investment law. And that is, of course, the whole treaty contract discussion, and with that, the interpretation and application of umbrella clauses. In 2003, he had sat on SGS and the Philippines. He was not the president of the tribunal, but nonetheless, you can read him in that. And what came through in that decision, 2004, then came to full fruition in his famous article of 2008 in Arbitration International, Treaty and Contract in Investment Arbitration, in which, with a spatial sophistication, with an eye for detail, but at the same time, a keen eye for perspective and what you would call the smell test. In other words, hold up the shirt. If it smells, then it's not going to, it's not the one to wear. You don't know why it smells, but there's something about it that smells. Well, to me, his reading of umbrella clauses and the relationship between treaty claims and contract claims marries all these qualities, the sophistication with, at the same time, a keen appreciation of what will fly in a way. So the idea of what you might call procedural internationalization, the idea that the breach of contract becomes a treaty issue rather than every single contractual obligation becomes a treaty obligation, to me is masterful. As is, I would have to say, the sophisticated understanding linked to that, although an exclusive jurisdictional clause cannot as such deprive the tribunal, the international tribunal, of jurisdiction, it's nonetheless a good reason for saying that the case is at least provisionally inadmissible. The sophisticated understanding of the relationship between those two contexts. And I would suggest that he was able to have this understanding because for many years he had written in the British Yearbook of International Law the section on international law in English courts, in which, and you read these little gems, these pearls of wisdom, you could see this very sophisticated understanding of the relationship between the two orders. And it was an interest and a passion we shared. I wrote them later for 11 years, and he, you could tell when he edited the things, which usually just involved a word or two here and there, you could tell, however, the pleasure, because he would tick things and this, that, and the other. The other thing that I appreciate in his investment stuff, although perhaps these days, of course, it means less, but in cases like Blue Sun and Italy, the understanding of the different legal orders and how they fit together, EU law and international law, Italian constitutional law and international law, and even the different treaty regimes, the Energy Charter Treaty and ICSID. And again, I think part of this is his general understanding and interest in international and domestic law, but the other is his background as a constitutional lawyer as well. At the University of Sydney, he taught a lot of constitutional law. In the Australian Law Reform Commission, he did a report on Australian courts and tribunals. And in fact, his best-selling book is on Australian courts and tribunals, not on state responsibility or anything like that. It's a basic text in Australia. So both his understanding and interest in constitutional law, and specifically actually, and this sounds ironic, within the context of the evolving international legal personality of Australia within, at the time, the British Empire, lent a sophistication to his work in this regard. So much so that in Blue Sun, there's a wonderful paragraph and a cheeky footnote in which he analogizes the position of the dominions like Australia, New Zealand, India even, within the British Empire to the position before a certain date of the member states within the European Union. And you could tell that he had a cheeky little smirk on his face as he wrote the footnote. On the personal level, for me, the most moving and striking thing is that the very first text I received on learning of his death was from a colleague of mine here at Bocconi, who also at the time was in Cambridge, and she wrote, "He was such a humane man." She didn't write, "What a loss of a genius." Rather, "He was such a humane man." And I think that's what most of us who had close contact with James would remember. And it's a wonderful personal trait, but it's also a trait that I think has influenced international economic law, because he was a great mentor, not in an active sense of sitting over your shoulder and telling you what to do, etc., but of identifying people, bringing them on, discussing with them, giving them opportunities where opportunities were possible. For example, if he was asked for someone who would be a director of studies at the Hague Academy, putting someone's name forward, or people who might be good for counsel or as arbitrators, etc. And so many people involved in the world of international investment law owe, I think, their start and their early career development to James, but not just international investment law. James is not known as a international trade law person, but when you think of the fact that he supervised the PhDs of Isabel van Damme, Freya Bartens, Wei Shun, and a range of other international trade lawyers, his qualities as a mentor and as a supervisor have fed into the discipline. He was not my supervisor, although he certainly gave me a kick up the backside during my first year exam in the PhD. He was punctilious, but at the same time, kind and humane. And it was always interesting to see at what time the emails arrived. My favorite email I ever received when working for him as a research assistant was at 4 a.m. on the day of his third marriage. Look, if you wake up before your wedding, why not get a few hours work done? And James always said that, in fact, he learnt his work routine through having children early. He had children while still doing his PhD and learnt to work around that. In his personal life and in his intellectual life, James was always what you might call quietly progressive. You have to reflect on how things were to realize how progressive certain of the aspects of the Articles on Responsibility of States are. Article 48, Articles 40, 41. You have to see some of the cases that he took as counsel. Now, you can say there's the cab rank rule, but it's not strictly speaking the case. Taking on causes in which he believed, but without being loud about it. He took on quite a few environmental cases. But the other thing he did is he advanced women in international law. He insisted that people be taken on as counsel in cases and so on. And when you look and you see the number of careers of women that he helped to advance, as a father of 4 daughters, I think it was personal, then you can see that he has, in other quiet ways, had an influence. So that's that from me. Céline, Fede, please, back over to you if you have other things to contribute. I can certainly say more, but I think at this point it might be good for us to hear more from you.
Céline, do you want to go ahead?
I can just pick up on something that Roger said. You mentioned earlier in passing the Supreme Court of Canada decision relating, well, the reference on the secession of Quebec. And I wanted to mention how much James had an impact on the Canadian international law landscape. I think probably no other individual has had as much of an impact. So he advised the Canadian government in this case, clearly critical to Canada, and he acted as an expert witness, and his influence on many aspects of the Supreme Court's unanimous judgment is evident. And in an interview he gave in 2018 in the context of the Cambridge Oral History series, James remarked on the significance of the judgment of the Canadian Supreme Court, which then fed back into the Kosovo advisory opinion, where he was a counsel for the UK, and also the work he did on the Scottish independence referendum. And he called such strands of cases largely happenstance. Like this happens to anyone else. But anyway, he was an expert in other cases in Canadian courts, including on the constitutionality of NAFTA Chapter 11 back in 2004. He played an arbitrator role as well in Canada in the early 2000s. He was on a tribunal to decide on the limits of the offshore areas of Newfoundland and Nova Scotia. And finally, I have to say, because I'm the current president of the Canadian Council on International Law, James has been a great friend of the CCIL for many, many years, coming to our conferences, including participating as a keynote. So clearly, James has left a great mark on the Canadian legal landscape and will be sorely missed.
Yeah, and so a personal anecdote, I worked on the Kosovo advisory opinion as his research assistant. And I think it is the absolute worst piece of work I have ever produced. He made me redo it. But even then, he never lost faith that I could do things. And that was incredibly encouraging. The fact that the first time you're writing, I had never written submissions for a state in an advisory opinion before the ICJ, as most people who were, I will not disclose how old I was, but I was young at the time. And he had gone away on a world tour that involved 5 continents in like 2 weeks, and had left me with this thing to do. He was unreachable. And so I just did the best that I could, and it was an unmitigated disaster. So he came back, he's like, no, this is the way. So literally like the mentor behind your shoulder, this is the way you do it. But what was remarkable to me about and how humane he was, how tolerant, and how what he could see, how he could see in people the good in them, that he never held that against me. At no point did he make me feel that I was not worthy of being his research assistant. On the contrary, he was always very happy to help you. So it was to me a great honor when he agreed to be my supervisor. I wanted to write about say responsibility, and he was very fearful that because of his role in the articles on state responsibility, he might be too much of an influence, and commenting too much on my work might sway me towards agreeing with his views. I am a contrarian by nature, so that did not happen. But we did plan on writing something together on necessity, and because we couldn't agree on what we thought about this rule, he ultimately decided that he couldn't write. And he said one of the nicest things that he ever said to me. He said, although I could be persuaded to your view, I have an institutional role to maintain. And this to me was, it just showed the integrity, something that Roger was commenting about, the causes that he took, also the integrity with which he approached his career and the projects that he did undertake. He knew the influence he'd had in the ILC articles, and how, sharing any doubts about that might affect the impact of what the project had done. And so even though it would have been an interesting thing to write together, he just thought, we just can't do it, because I cannot make you write things that you don't believe in, and I cannot take a different position. So that was, for a young PhD student, that was terrible. I wanted to write something with James Crawford. But at the same time, it just showed to me how, you need to stand by your beliefs, and you need to stand by the things that you think are right. And so, again, as another example of this, on an opinion we wrote for one of his clients, he pushed back on arguments the client wanted to make because they were just not right. I think they probably involved umbrella clauses, Roger. And I just thought to myself, this is the kind of professional I want to be. This is the kind of, if I ever go into practice, this is the kind of practice I want to do, practice that I believe in, cases and arguments that I think are correct as a matter of law, and also as a matter of integrity and morality and so on. So it was very inspiring to be both, his research associate and then his PhD student. As a PhD supervisor, yes, I criticized him a lot, and he was always incredibly fair, sometimes providing, some information as to why things had gone the way they went. And certainly being his PhD student did involve meetings at 8 a.m. in the mornings on Saturdays. He once fell asleep while I was there because he had just returned from Australia, a weekend in Australia. And then having my final meeting with him in The Hague. I chased him there because he said, oh, we can talk about this in September. And I said, no. And so we had this lovely last supervision in a sunny spot in The Hague while he was busy with the Hague course and the whaling case. And it was just a lovely way to end the long project of a PhD. And he said, this is ready, it's good to go, well done. And that to me was, that day was just a fantastic day. So lots of memories to share about James, yeah.
Well, I have two more things, and one of them I'm sure Federica will know all about, as will Isabel and Freya, and perhaps Céline too. And that is James's approach to writing. When you read things, judgments and articles, there is an elegance in the spareness. James, avant la lettre, had the same rules of writing as Elmore Leonard. Basically, no adverbs. Unless that adverb was something maybe once every 5 pages, very. Something like that. No adverbs. Simple structures. Keep it direct. Write it as you might say it, although not completely as you might say it, because James's writing always maintained absolutely correctly a level of formalism and formality. And I remember once writing something for him, and he sent it back, said, this is great, but send it back to me in half the length. And I thought, well, how can I do that? And then when I sat down and read it, and I realized, although not overtly, but in essence, I'd made the same point a few times. I could get rid of that, compact that. I could take out all the adverbs. And then you realize you do it again and again. And he went through this process again and again and again. And you realize just how simply, directly and clearly you can say things, and how simply, directly and clearly he said things. I remember Isabel van Damme saying to me, James has just given me a short story by George Orwell called Shooting an Elephant, about George Orwell's time as a policeman in Burma, to read as part of my PhD. Great. He said, write like that. Write like that. And it was a window into another aspect of James's life, and that is that although work was central, he had a very, very rich literary, musical, historical, philosophical knowledge, interest, and indeed passion. He could speak of novels and concertos and this, that, and the other. It wasn't just work. The point on which I think I might leave relates to falling asleep. So James knew that his professional life had a personal cost. He once said to me, although I'd have to say this is before he found final happiness, he once said to me, don't do what I did. And what he meant was, don't work yourself quite so hard. The point, of course, is that he wouldn't have had it any other way. But how should we put it? Side effect of this, of course, is his famous fatigue. He was always falling asleep. So at the Lauterpact lunchtime lectures on a Friday, he was famous for what was called the screensaver, that he would be chairing the thing and actually nodding off behind the speaker. But he was not asleep. He would wake up and then ask this question, which went straight to the point. It was like he had it just ticking over and whirring over. Some of the people in the audience, I think one time Loretta Malintoppi, I think Jan Paulsen would have had this on many occasions, because I remember dinners at Cambridge, at Jesus College, when James was doing an arbitration or something. He would invite everyone there, as well as some spares, the president of the International Court of Justice or something. And things would start slow because, you're sitting next to the president of the International Court of Justice. What do you say? And then after a few wines, everyone's loving it. And, my God, I'm speaking to all these people. And it's really sort of international law nerd heaven on earth. Meanwhile, James down at the end has slowly nodded off, taking great pleasure in the fact that his friends are there, all talking to each other, and that he didn't have to do the talking. So he's nodding off. And just as the conversation was really reaching its peak, coffee came, we had our coffee. James would sit bolt upright at 9:30 on the dot and say, well, we've all had a lovely evening, thank you. And that was it. We had to go, because James had to go to bed. But when I reflected on it, I thought, what a wonderful approach. First of all, leave while the going's good. And second of all, friendship and enjoyment should not be a chore. So when he got to the point where he was tired and he had to go to bed, we all went to bed. And perhaps that's a nice way of leaving it. James, a bit like our dinners, left us too soon. We all had to go on without his presence, but left us with many wonderful memories and many things on which to digest for the rest of our professional and personal lives. Unless, Céline, you want a final word, or Fede, you'd like a final word, that would be a nice place to leave it, I think. And of course, the final thing, of course, is to say, as has already been said, but nonetheless, to note ours, and I'm sure the Society's appreciation and condolences to Freya and the wider family. And on that note, I will leave you all with your memories, and thank you for tuning in. Thank you, Céline. Thank you, Fede. And enjoy the weekend, and forza gli azzurri.
Bye, everyone.
Ciao.
Thank you.